Hello. This is the introductory video for the half option Incentivizing Aesthetic Progress, Intellectual Property, Art and Design. My name's Emily Hudson and I'll be the convener of this course. This is a new half option in our intellectual property offerings. It's open to students studying the BCL MDUA and also to those enrolled in the MSc in Intellectual Property Law. So in this video, what I propose to do is to provide some background to the course and an overview of the syllabus, and then also cover a few matters in relation to the teaching pattern and the assessment. So let's start with the background of the course. And you may be asking yourself, Incentivizing Aesthetic Progress, what's all that about? So I suppose we might start with what sort of works we're dealing with here. And as noted on the slide, the works we will consider range from fine art to the applied arts to clothing and product design. So we're interested in creative works, bearing in mind too that although our focus is more on the visual arts and design, we will mention other creative outputs, so literature, music, and so forth, and the sorts of ideas we cover will also be relevant to those outputs. So let's talk a bit more about what the course is about. And the idea behind it is to go beyond IP doctrine, to ask what sort of legal, economic, social, and cultural climate can encourage creative production. So that's the idea of aesthetic progress. That terminology can be traced back to the intellectual property clause of the US Constitution and some of the discussions around that clause. That clause says that Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Now, to be clear, we are not doing a course on US constitutional law, and indeed, this is just a springboard for the language of the course and its themes. But importantly, when you look at standard accounts of why we have copyright law, why we have designs law, what you'll see is this sort of the centrality in many of those accounts of incentivization. That in the absence of the exclusive rights that intellectual property law provides, free riders would be able to copy the outputs of designers and artists without bearing the costs of creation. So designs law and copyright law have been said to encourage the creation and dissemination of new works because they allow creators to capture the benefits of those works. But this raises a number of questions. And one question is whether these rights provide meaningful incentives to create. Are they necessary to have a rich creative environment? Bearing in mind that for thousands of years, thousands and thousands of years, humankind has been engaged in creative output, all without a formal system of intellectual property laws. So what is it that drives creators? Another set of questions relate to what sort of creativity, what sort of aesthetic progress we want. Some of you may be interested in studying incentivizing innovation as a companion to this course. And I think that when we're thinking about technological and scientific innovation, the question of what we want is a bit less contentious. That is, we want greener technologies, we want cleaner ways of producing energy, we want new drugs, we want new antibiotics, etc. In contrast, when we're thinking about aesthetic progress, the question of the right sort of work is far more problematic. So, for instance, is progress more mashups and memes? Or is it more genuinely novel creation? Is the latter even possible? So let's now turn to the syllabus. And as indicated here on the slide, we've got an IP plus syllabus. And what I mean by that is that there is doctrine, a core amount of doctrinal content, but we also want to go beyond that doctrine. So here's what we're going to do. First of all, we need to make sure that everyone has solid IP foundations so that we can all engage with the critical themes in the course. So we'll cover important aspects of designs and copyright law. As an aside, in presenting this information, in presenting this material, we'll be working on the basis that some people either may not have studied intellectual property law, may have studied an IP course that did not include designs. And indeed, many undergraduate IP courses don't include designs as part of the syllabus. Or there are people who have studied designs, but it was sufficiently long ago that they so you don't need to have designs correct knowledge on the way in, you'll have it on the way out. Bearing in mind, also presented in a way that allows plenty of time for juicy bits. So what are those additional juicy bits? Well, as indicated on the slide, we're going to be stepping inside the mind of the creator in a number of ways. So one thing we're going to do is look at what neuroscience teaches us about creativity and creative production, and how this maps onto understandings of creation and authorship in IP law. We'll also look at AI and how AI is being used in creative production. We'll look at some of the litigation that's taking place at the moment, which relates in particular to training of generative AI. We'll look at questions of whether AI can be creative. We'll consider AI's impact on the creative economy. Another important topic will be social norms. So the idea of a social norm is that people cooperate and coordinate either in the absence of law or in ways that fill gaps in legal regulation, or indeed they act in ways that might be contrary to what the law says. And there are lots of creator norms in relation to art and design, and so we'll be talking about social norms theory and then looking at examples from the creative industries. Final indicative topic relates to capital, labour, and the state. So again, we're going to look beyond IP law at other legal and political and economic factors that are relevant to supporting art and design. So, for instance, one theme is how emerging artists deal with established market players, negotiation of contracts, particularly in a context where there might be quite an imbalance in bargaining power and so forth. So this aspect of the syllabus will include themes that are relevant to commercial practice more broadly, for instance, because of the emphasis we'll have on commercialization, enforcement of rights, and so forth. So who is this course for? Well, I've said here it's for everyone. I would say that, of course. So let's drill down in a bit more detail. It's clearly of interest to IP nerds, but even if you don't classify yourself as an IP nerd, it may nevertheless be a great course for you. So if you're interested in the creative industries, if you're interested in particular in art and design, but indeed any of the other creative industries, I think this course will be of interest. Our focus on social norms and the law in action means this course will be attractive for those who enjoy viewing the law through a socio-legal lens. Our examination of the science of creativity will be of interest to those of you who enjoy neuroscience, psychology, and the like. And there's also going to be a strong sort of philosophical content. We're asking why we have IP law. What's it meant to do? Does it do it? Is it desirable? So that will be really of interest to the jurisprudence. This is a half option, so you'll need to have another half option you study alongside it. Just wanted to have a call out to the other IP focused half options, which are all would be fantastic bunkmates for this half option. Incentivizing innovation has a very similar intellectual approach in terms of being an IP plus course. I think it could be a really lovely combination to see in Michaelmas. Incentivization as it relates to scientific and technological innovation, and then in Hillary looking to incentivization as it relates to the creative industries. I think it could be a really lovely partnership. If you're a copyright enthusiast, this would be a great course to take alongside comparative copyright. They're both Hillary courses, but the assessment is such that there are no overlaps there, so you can take two Hillary half options simultaneously. It's also a great partner for trademarks and brands. So if you're interested in product design, if you're interested in branding, there's clear synergies. A lot of the designs we're talking about, they're much more industrial in their orientation. So great partner for trademarks and brands. Teaching pattern, as I've already mentioned, this is a Hillary half option. There'll be 8 seminars and a program of 3 tutorials, likely in a Saturday time slot. So that's in particular because this course is open to MSc in IP students. We want to make sure that you have a non-weekday time slot, and this will likely be the half option, which has that Saturday time slot. And assessment, it's via submission. So that's research essay. So in week -1 of Trinity, we'll release 6 questions, all drawing from material covered in the seminars and tutorials. You'll then have, I think it's then almost a week to write 2 essays of up to 2,500 words. So you will then submit those, and that is the assessment done before Trinity begins proper. So that's, I think, sort of maybe quite attractive to some of the BCL students to get some of their options and assessment all done and finished before the big assessment period in Trinity. So that's it for me for now. Thank you so much for your interest in this half option, and I hope to see many of you in Hillary. Thank you so much for that.